Part 4. Yehuda Ferris and William John Rogers attempted to file a civil restraining order in probate court, but it was rejected and rerouted to a civil department where the standards for issuing restraining orders are significantly higher. This is probate case RP221-20163 in Alameda County. This is the trust of a cancer patient that was liquidated, and the siblings didn't get anything. So moving right along here, so Ferris, the trustee, and Rogers, his attorney, attempted to file a civil restraining order in probate court, but it was rejected and rerouted to a civil department where the standards for issuing restraining orders are significantly higher. In their petition, they sought to prohibit the user from speaking to the media, prevent public discussion of the trust case, to stop the user from embarrassing the trustee, harassment, retaliation, and attempted gag order. Service of the restraining order application never occurred. The process server went to the user's sister's house, knocked on the neighbor's door, offered cash bribes to anyone who would reveal the user's whereabouts, trespassed onto private property. Because the user was never legally served, the restraining order proceedings could not move forward. The judge allowed them to dismiss without prejudice. Soon after the dismissal, attorney William John Rogers of Petaluma, California, law license 154219, sent the user a threatening letter stating if posts were not taken down by a certain immediate date, another civil restraining order would be filed, that if not obeyed would result in the user being arrested and the user will go to jail. The letter also threatened the user with a libel lawsuit. Civil service of the restraining order application never occurred. The judge reviewing the order application warned Yehuda Ferris of Chabad of the East Bay and attorney William John Rogers of Petaluma that the petition did not meet the legal standards as it was not served and would be dismissed if they did not withdraw it. Then they voluntarily dismissed the restraining order without prejudice, ending the attempt to silence the user for the moment. It is important to note that attempting to use a civil restraining order to stop someone from speaking to the press, discussing a legal case, or criticizing an attorney or a trustee violates core First Amendment principles. Legal scholars and courts have repeatedly held that such gag attempts are often unconstitutional prior restraints. The dismissal implicitly acknowledges